Surely a judge can have no task more terrible than deciding which of two warring parents can bury their deceased infant child. That decision faced Justice Harrison in this case. AB and CD were teenagers when she fell pregnant with baby M. She fell out with her mother and some months after the birth moved in with a new fiancé. Just after M's 14-month needles, he was found unresponsive, resuscitated and taken to hospital where he was ultimately removed from life support. Even before that sad moment, hospital scans showed bruises on baby M, including his brain. Justice Harrison said, "Although it is not for this court to make a finding on the cause of M's death, it appears clear that the plaintiff, her fiancé, or some other person within the fiancé's house may have been involved in M's death. Whether or not any suspicions are justified cannot presently be resolved. That suspicion reasonably exists is self-evident." The father argued the mother should not decide baby M's funeral arrangements while under a cloud of suspicion. However, she was still at law and may have been, in fact, completely innocent, and a funeral could not wait for a trial or an inquest. His Honour reviewed the authorities and found that usually funeral responsibilities went to the executor of the deceased person, but this hardly made sense for an infant. Previous courts had also focused on practicalities, but those ignored the deep emotional context of a case like this. Justice Harrison said that while the parents accepted the need for practical considerations, their arguments invited a consideration of significantly more arcane matters such as love, sentiment, grief, responsibility, and even anger. It would, in my opinion, have been curious if these matters had not become prominent in the present proceedings, and wrong to exclude consideration of them when they did. Ultimately, baby M's mother, with whom he lived his whole short life, arranged his funeral. From this case, we learn two things. First, even heavy suspicion of involvement in the death is not enough alone to disentitle the suspect from funeral responsibilities. The presumption of innocence stands. Second, we learn that for a child who has no estate, the usual approach of appointing the executor to make funeral arrangements will not work. The court must balance practicality and emotion to allow the deceased child to be laid to rest with dignity.